And good afternoon. Welcome to Facebook Live. Ask a Lawyer on Facebook Live. I'm attorney Michael Bender.
And I'm attorney Allison Tilton, and we are the Gray Legal Group.
Well, the contents of this video is for general information purposes only. Nothing should be taken as legal advice for any individual case or situation. The information is not intended to create, and receipt or viewing does not constitute an attorney-client relationship.
One day
right?
we're going to get through that with we're
No.
just going to get through it.
No,
right?
we won't. It's definitely not going to happen. Topic of the day, ATROs. Well, automatic temporary restraining orders. These are those, we refer to them as ATROs. Nice little acronym there. Basically the protections that go into place right when a case is filed.
This is on page 2 of a summons, and they say standard family law restraining orders. Even though we call them automatic, they say standard. It's one of those weird anomalies, but judges and attorneys always refer to these as ATROs.
And not to be freaked out, restraining orders,
right.
It just means you can't do certain things. So,
right. So
we're
gonna talk about two of those today.
Well, the first question,
right.
Why don't you go ahead and talk about the first question here. Soon to be ex canceled my health insurance benefits. I'm currently going through a divorce and just learned that in January, my soon to be ex-husband canceled my health insurance with his employer. Our divorce is not yet final. I was never notified and I'm now past the 60-day window for COBRA. How can I get reinstated or have him get me back on the coverage?
Okay, so real quick, one of the ATROs deals with insurance, and this is basically a very broad insurance restraining order that's in effect that basically says all insurance that was in place at the time the divorce was filed stays in place until you've got a judgment. So that's life insurance, health insurance, automobile insurance, AFLAC, accidental, every kind of insurance you can think of. All insurances.
Basically maintain status quo.
Right, maintain status quo. So if your husband maintains your health insurance, he has to maintain that health insurance. He cannot cancel the health insurance during this case. He can't, so really the fact that you were never notified and that you're past your 60-day window on COBRA doesn't really matter because it's not your responsibility to COBRA the health insurance through his employer. It's his responsibility to maintain your health insurance and not cancel or otherwise change it. So we typically say don't file an ex parte unless it has to do with custody visitation. This is going to be one of those exceptions where I would say you need to file an ex parte with the court and tell the court that he has violated the ATROs or that you believe he's violated the ATROs and that you need to be immediately reinstated on health insurance. And the reason that I say that this is appropriate for an ex parte is because if you file this on the regular request for order calendar, you're not going to get into court for 60 or 90 days, and you don't know what's going to happen in those 60, 90 days. So this is one of those emergencies where the court would listen and that they would order you to be put on health insurance. It's probably going to cost your husband a fortune because it's probably not open enrollment for his health benefits. And kind of like too bad, so sad to him, he's going to need to take out a health insurance policy that is comparable, if not the same as the health insurance that you had through his employer.
My 2 cents, of course, real quick. How can I get reinstated? There's really nothing that you can do. You don't need to contact the insurance agency. It's going to be up to your husband to make sure that he does everything. And yeah, too bad, so sad. If he can't get you back on there, he's going to be out of pocket to make sure that you're covered. So
probably a lot more money than it did to just pay the coverage through the employer.
And the judge isn't going to be happy that.
No, judge is not going to be happy at all. All right, so our second question deals with the ATRO with children. Can I take our children out of state? I asked my ex if I could take our 3 children to Nevada for the weekend. He verbally said yes. Now the day before I'm ready to leave, he says I can't go. He has threatened to call the police if I go. He takes the kids wherever he wants on his weekends. When I want to go out of state, it is my weekend. We already have hotel reservations that I can't cancel. Can I take them since he verbally said it was okay to go? I just had one thought about this before you answer this. We discuss these before we go live occasionally.
Pre-prep,
and I think when we discussed this, we were assuming this case is pending, but this question does not necessarily say that it's pending, so I think you should answer it both ways.
Oh, thank you.
And go.
I actually have a third curveball in there. First, well, to address if there's not a case pending, there's no case pending.
No, I meant pending versus judgment. Pre-judgment, post-judgment.
What if there's not?
Well, so
what
there's
if there
still
is
case
no case?
pending.
What if
Okay,
there's no case
if there's
filed?
no case, right?
There's no case filed.
Yeah.
There's no orders.
Okay.
If you have a mutual agreement, handshake agreement, you can go ahead and take the children back, provide the itinerary, go, come, as you please.
Okay.
If the ATRO is in effect, if there's a case pending, you've been served, or you filed a case, he's been served. ATRO number 1 is the children cannot leave the state of California without written permission from the other parent or a court order. Keywords there, written permission. So verbal permission, it's not going to get you anything. You really, not within the time frame to file an ex parte to get court permission. So the crux of the question, can you go because he said it was verbally okay? If you have a case pending, my recommendation would be not go. File a request for order down the line so you can get the option in the future to provide itineraries, to say, okay, this is where I'm going to be going on my weekend or my vacation time, and get an order that allows you to go outside of the state of California. Post-judgment, typically post-judgment, that's the third scenario here, post-judgment is anywhere in the U.S. Typically, you have to look at the orders.
Yeah.
Some orders specifically say that parents may not take the children outside the state of California. Very rare, though. But once judgment's in place, anywhere in the U.S. is perfectly fine.
I think that covers it.
All right.
All right. So thank you for watching. Thank you for joining us on this week's Ask a Lawyer. Join us each week as we discuss family law issues important to our community. If you have a legal question or topic you'd like us to address, go to thegraylegalgroup.com and click on Ask a Lawyer. We'll see you next Tuesday at 1:30.
And if you haven't done so yet, like us on facebook.com/thegraylegalgroup.